Hi, I'm Toby Spiro, Education Director at AWFS. I'm here to introduce Ashley Amadon, who's the Executive Director of the IWPA. She's going to be speaking today about the Lacey Act and new updates that are going into effect this year. I'll say I had the pleasure of full day training on this recently, and I can say it's definitely really, really important for our industry. And those people watching this that haven't already done a little bit of research into it definitely should get started. It's a deep and broad topic. So thank you, Ashley, for coming, and I'm just going to let you take it away.
No problem. Thank you, Toby. And it was such a pleasure to have you out in California with us. That was a very, very full day of training that you attended. Well, welcome everyone. As Toby mentioned, I am the Executive Director of the International Wood Products Association, and I am here to tell you about maybe not everything you need to know, but at least some of what you need to know about the Lacey Act. So I got to do my little mandatory disclaimers. I am not a lawyer and I'm not going to read this entire thing, but essentially there are a couple things to take away that I just want to make very clear at the outset. One of those very important thing to note is that the training that IWPA offers and that this presentation is based on is something that we've been working on at the association since 2015. And so a lot of different organizations and groups and people and companies have been involved over the years in sharing some of their knowledge that we have added to the training. That does not mean that anything you're about to see or any training that we offer is an official reflection or an official statement by any of the people that have been involved. The other thing that I want to specifically note is that I am not a lawyer. This is not going to be legal advice. I always tell everyone, I'm going to tell you some very broad things about the Lacey Act, how it might apply to your companies, your organizations. But if you have specific questions for your business, you need to talk to your customs brokers and your lawyers. So with that out of the way, here's what we're going to be talking about today. I will give a very brief overview of the Lacey Act history. We'll talk about the 2000 amendments. We'll discuss what is in and what is out of the Lacey Act. Of course, the Declaration, which is the reason I'm here today, and jail fines and other enforcement information, including a case that just happened last week. We'll talk a little bit about what compliance looks like, and then we'll talk about what you need to know about complying in 2024. And then I'll leave a little bit of time at the end for questions. So with that, a very, very condensed Lacey Act timeline. I like to joke a little bit that my sex is to blame. The Lacey Act actually came about because of women, specifically their hats. Around 1900, there was a fashion for big giant hats with tons of feathers. I'm talking whole actual birds in some cases. And as a result of this fashion, many birds were being hunted close to extinction. And so the Lacey Act was passed at the time to deal with interstate commerce. There were some states that were outlawing the hunting of specific birds. Let's say it was illegal, to hunt this bird in Pennsylvania. Well, you could kill it in Pennsylvania and take it across the line into Maryland and sell it there perfectly legally. So the Lacey Act was a way of, over this patchwork of state laws, right, creating federal oversight to ensure that laws could not be broken simply by crossing the state line. Now, between 1900 and 2008, there were 6 different amendments to the Lacey Act. It covered fish in the 80s, as well as, I think back in the 20s or the 30s, established both individual and corporate responsibility. I share this not because these amendments are particularly important for our discussion today, but because it is a way of showing that this is not a new law. Our industry came in 2008, but there is 124 years of case law on the Lacey Act that it builds upon. So in 2008, plant and plant products are added in the 2008 Farm Bill. This is the point at which our industry becomes involved. And so it's from 2008 on that our industry has to deal with the Lacey Act. Now, what's interesting about those 2008 amendments is because for the first time, there was something called an import declaration added It's referred to colloquially among the government folks as PPQ 505. You can also call it the Declaration. They can be used interchangeably. Now, at its most basic level, the 2008 amendments forbid the trade of illegally taken plant or plant products. I'm not going to read this entire thing, but essentially, if at any point in the supply chain from the time that, that plant is planted to the time that it hits a consumer's home, if at any point in that supply chain a law is broken, then that plant or plant product becomes illegal or illegally taken. Now, I thought it might be helpful just at the front end to set a bit of expectations in terms of what are the products that you might be dealing with that are covered under the Lacey Act. And Toby was kind enough to give me a couple examples: MDF, plywood, veneers, solid wood. And again, I want to emphasize that this is both domestic and international. So obviously, if you're importing wood, you're going to be covered by the Lacey Act. But if you're taking it across state lines, then it is also covered. So this is going to be both domestic and imported products. So there are two primary responsibilities under the Lacey Act. The first is the responsibility to conduct legal trade in all plant and plant products. And now this is for the entire supply chain. As I mentioned a couple slides ago, if at any point in that supply chain, a law is broken, then that plant or plant product becomes illegal. The second is that new responsibility I mentioned that came in 2008, and that is to make a Lacey Act declaration. Now, it's important to note, all plant and plant products are covered by Lacey right now. They have been covered by Lacey since the passage in 2008 of those amendments. The declaration is an entirely separate responsibility, and it's been phased in pretty gradually based on the HTS codes. This declaration form is a responsibility placed on the importer of record to file. Now, I mentioned the HTS codes. IWPA was actually the first industry covered by Lacey because some of my members import raw lumber right along. So that was a pretty easy thing to say, yes, this is obviously covered by the declaration, relatively easy to fill it out. But obviously, the farther you get from that log, the more complex the supply chain becomes, the more complex the product identification becomes. And so APHIS, which is the Animal Plant Health Inspection Service, APHIS regulated everything under the Lacey Act, but decided to phase in the declarations based on the complexity of it. So if you take one thing away from this, take a picture of this slide right here. The whole supply chain matters. If it is illegal in one place, then it is illegal everywhere. There is no protection that you can have simply because it was 10 steps back in a supply chain. Even if you are not the importer of record, you still have to do due diligence. There are a lot of folks that they hear Lacey Act and they think, oh, that's an import thing. I don't have to worry about it. I'm not the importer of record, right? That is not true. Lacey is a strict liability law. And what that means is that you don't have to have committed the crime or even have been aware about the crime being committed, and you still have liability. And you'll see this when we go into depth on a few of the enforcement cases. So what does this mean for you? So the questions that we have people ask themselves, right? You have to know your supply chain, know your product, and know your supply. These three things are at the sort of core base level of what it means to do Lacey Act due diligence. And Toby will know this. These are the three key words, right? We had everybody chanting them quite loudly at one of our in-person trainings: source, species, and supplier.
I promise not a cult.
I was fully expecting you to jump in there and start chanting them for me. But these three key words are incredibly important, because if you don't have a knowledge on your source, your species, and your supplier, and the government comes knocking at your door saying, hey, we think you have a Lacey Act violation, and you're like, well, I mean, I just buy from this guy and like, I don't really worry about any of the details. you are going to be in a lot of legal trouble. So one of the big questions I get is, what is covered, right? What of my plant and plant product materials are covered by the declaration? Now, again, I want to emphasize this is covered by the declaration, not covered by the Lacey Act. So in terms of the paperwork that you file upon import, pallets are not covered by the declaration when they are used for dunnage. However, if you import a container full of pallets as merchandise, right, like you're importing them, you're going to sell them on, then those do need a declaration. Another exemption is common cultivars. So these are commodities, and APHIS has a great list. If you, because you obviously can't click on this link, just Google APHIS common cultivar. And that will give you, they have a section on their website where you can put in any keyword and it will tell you if it's covered, so you can search that way or just browse it. But essentially, if it's a common food crop, then it's not going to be covered. So for example, ears of corn, right? Technically, that's a plant and plant product. It's not covered. I do also want to specify if anyone here trades in CITES listed species, CITES being the Convention on International Trade in Endangered Species. Simply because you have CITES paperwork does not mean you are exempt from Lacey. CITES is a totally separate process, totally separate paperwork. So just be aware that those are not, you know, they don't give you a checkoff for one versus the other. And if you have a question on how CITES interacts with anything else, feel free to pop that in the question in the chat, and I'll happily answer that at the end, because we do a lot of work on CITES as well. Another big question I often get relates to bamboo. So APHIS actually has guidance specific to bamboo, I think, because they were also getting this question quite a bit. And I want to be clear here, bamboo covered by Lacey, but in terms of the declaration, cultivated bamboo. So essentially bamboo that is planted for the purpose of using it commercially, right? Plantation. That is not covered by the declaration. So if you have plantation bamboo, you do not need a Lacey Act declaration. However, if your bamboo is wild or mixed, or you don't know, then you do need to file a Lacey Act declaration. And again, they have full guidance on their website. Just Google APHIS bamboo guidance, and it will give you everything you need. So I mentioned APHIS a lot. That is it's under the USDA, US Department of Agriculture. It's the Animal Plant Health Inspection Service. APHIS is the government agency that is tasked with overseeing the actual declaration. I've also mentioned it has a phased-in approach. We are actually in phase 7 now, and that well, I guess we technically are about to enter it, but it's been published in the Federal Register. There is a 6-month implementation deadline, meaning that as of December 1, any products that are included in phases 1 through 7, you have to file a Lacey Act declaration for. And I know you're wondering, well, how do I know what's in phase 1 through 7? Well, it's pretty easy at this point because we've gone through so many phases. If your product is anything but purely composite wood products, it is covered. APHIS has examples of what they consider purely composite materials, and that includes paper, paperboard, particle board, MDF, and HDF. If it is not in that category, then it is almost certainly covered by phase 7. If you have a question on whether your product is covered, feel free to shoot me an email. One of the things that was great about, IWPA is a close relationship with APHIS is that I'm happy to send a question, and it can be anonymous. It doesn't have to come from an individual company, where I can say, hey, I have a question about X product. Is this covered? And then I can forward that information back to you, or I'm happy to connect you directly with APHIS if you'd like to have that conversation. But essentially, if you are not included in this purely composite material, then you are filing a declaration. I've talked with some folks that have products that are a combination of composite and not composite. So it might be a dresser where parts of it are solid wood and parts of it are going to be composite products. You still have to file a declaration for that because some of it is not purely composite. So it is truly only going to be an exemption from the declaration for now if you are 100% composite material. So what is actually on this mysterious PPQ 505? What do I need to worry about if I'm filling out a declaration? So there's two main categories. You have the basic business information, and then you have product-specific information. Now, most of this on the basic business information, if you are a legal law-abiding business, should be pretty easy to fill out, right? It's things like addresses, the description of what it is, your name, the code, container number, right? Basic information that you should be able to access. Where it can get confusing is when you are entering product-specific information. So I think the step that trips the most people up is the species and genus, right? Because a lot of folks in the trade will use trade names or, common names of a wood. They're not calling it the actual genus and species name. And so you have to make sure that you have that scientific genus and species name listed and not a common trade name. You also have to make sure you have the country of harvest, the quantity in metric, and then the value of the product, not the component. So I have this picture up here because it's helpful for people to take a look at. I do want to say that this information is filed almost exclusively electronically at this point, rather than via this form. You can file in the ACE system if you're a customs broker, or APHIS has an online system called LAWGS, LAWGS, because it's such a clever name, right? And both of those allow you to go through and fill out this information. However, quite frankly, both of those systems don't allow you to have all the information in one picture. So that's why I'm showing you a picture of the paper form. But you should not be filing via paper at this point. You should be filing electronically. And as you can see, you have all of that business information for the most part up here, right? And then this is what it looks like down here. You're going to need to make sure that you have the genus and species, the unit of measurement, if there's anything, percentage of it recycled. All of that information has to be filled out accurately. And then at the bottom, there's a line that says, by signing this, I am certifying that all of this information is true and accurate. Whoever signs this needs to be aware of the details. I met with a company recently where they had their office manager signing it because this woman handled a lot of the paperwork and was just, signing things. They didn't understand that the liability for the information on this form rests with the individual signing it. And I do want to be very clear, just because your customs broker is filing this form does not mean that your customs broker is liable. The importer of record is the one that is liable for this information. So I've talked about how it's a strict liability law, but the frustrating part about Lacey for a lot of people is that due care under this law is not defined or specified, right? There are a lot of laws and regulations where it's very clear the steps you have to take to comply. It's forms you have to fill out, it's training you have to do, whatever it is, right? The Lacey Act is not like that. Now, if there's no guidance at all from the federal government, right, how do you know what to do? Well, there have been quite a few enforcement actions. And so each of these enforcement actions, now keeping in mind, of course, that an enforcement action or a court case, right, if you take someone to trial because they've broken a law, any settlement is going to be punitive, right? You want to punish them for the wrongdoing. And the settlement is going to be very focused on what they specifically did wrong. That being said, all those grains of salt, right? If you look holistically at all of the enforcement actions, then there are certain common elements that you can see across all of them. And so we can look at those common elements and identify them and say, okay, the US government believes, based on these, it's in 5 of the 6 enforcement actions, right? Or 6 of the 7, that this is a basic level of due care that the US government is expecting to see. So let's talk a little bit about those enforcement cases. This is unfortunately the least fun part of this presentation. So this is what violations will cost you. Keep in mind that these numbers do change. They update every couple of years for inflation. I think they're set to update later this year. But for now, at least, you can see it's broken down between civil, criminal misdemeanor, criminal felony. And the real test is under civil, right? The defendant should have known. It's negligence. Criminal, right? It's gross negligence. Criminal felony, the defendant knew. And so it's really, I mean, you don't want to be in any of these categories, but you especially do not want to be in that criminal felony category, because as you can see, the penalties go up exponentially from $10,000 fine and forfeiture of goods all the way up to, it says 250, but all of the settlements, as you'll see, are much over that. I do also want to note, the goods are forfeited no matter what. There is no innocent owner provision within the Lacey Act. If you are found guilty of violating the Lacey Act, then you lose that product. Now we're going to walk through some of the big enforcement cases. These are simply the ones that went to trial, right? That are reported on. There have been many, many more. I'm personally aware of many more where it never went to trial, but there was a small fine paid, and the goods were forfeited. And by forfeited, I mean, they're burned. In one case, they had at a port, like out on the dock, they basically rolled construction equipment over it until it was splinters. In a very few cases, they will donate it to someone like Habitat for Humanity, but the donation cannot cross state lines and it can never enter the stream of commerce. So, if you violate the Lacey Act, you are absolutely losing those goods, period, end of discussion. So let's talk a little bit about what that cost has been. So the first enforcement case is the one that probably most people are familiar with because it was really big news at the time. This was in 2012, Gibson Guitars. They had 2 issues under Lacey Act, 2 separate alleged violations. They were able to reach a deferred prosecution agreement. It's a 5-page compliance plan, and you can Google this, just Google Gibson Guitar Lacey Act settlement, and it will pull this up. What I like to emphasize about Gibson Guitars is Gibson was not the importer of record. It was a small company called Luthier's Internationals, I think a 1-woman shop, and she still got in trouble too. But it's worth noting this is not called the Luthier's International case. It's called the Gibson Guitar case. And what this demonstrates to me is that the US government is going to go down the supply chain, right? They're not just going after the importer of record, the person filing that declaration, who's the initial importer. It is how far down can they go? How far down can they prove that you should have exercised due care and found these problems? So if you're listening to this and you're thinking, well, I'm not an importer of record, right? That does not mean that you have protection. The next one is J&L Tonewoods. This is interesting because it is a domestic company trading in domestic products. They were illegally taking maple from a US national forest and taking it across state lines. The company went out of business. Multiple people in the company got jail time, as well as additional probation. And then they had the $159,692 in restitution. Next, we have Lumber Liquidators. They now trade as LL. This was 2016. Now, again, notice that the 5-page compliance plan, now we're up to an 8-page compliance plan. Their business was also supervised by the government for 5 years. But I particularly want to draw your attention to the penalties. A little over $13 million in penalties and payments. The US government has slowly ratcheted up what it's looking for, both in terms of what it's looking for from compliance, but also what they're willing to give as, settlements or penalties. So next we have Young Living. They're an essential oils company. They have $760K in penalties and payments. What's particularly fascinating about this case is this is a self-reported case. They realized they were doing things incorrectly, went to the government and said, hey, we understand, like, we've found this in digging in our own company, and we want to self-report so that there's no problems further down the line. For self-reporting, $760K in penalties and payments. And when we teach the class, you can sort of see people's jaws drop, right? Because they're like, I'm coming forward and, I'm fully disclosing to the government, I've done something wrong. Why are they charging so much? And we always like to point out that it is better to pay that 760K that the government fined Jen Living for, rather than the government coming and finding those problems on their own. Because can you imagine what those penalties would have been like? Think back, Lumber Liquidators was the year before this, $13 million in penalties. So it's never great if you have to go to the government and say, hey, I'm whistleblowing on myself, essentially, but it obviously means a much lower fine. So this was until last week, the most recent case, and that is the Quintanas. So this was, they were sentenced on Valentine's Day this year. And essentially it was a couple down in Florida that were importing product, trying to evade duties on product from China. And so they were lying about where the products were coming from. They were transshipping them different places. They ended up fleeing when the government found out. It's a very long and interesting story. But at the end of the day, they were dragged into court and had a little over $42 million in forfeitures, as well as $1.6 million in storage costs, because some of the product was actually caught at the port, and so they had to store it for the duration of the legal case. Each member of the couple was sentenced to 57 months in prison, 3-year supervised release, and they're prohibited from engaging in business related to the Lacey Act. So this is showing clearly that the Lacey Act has some teeth. Now you're probably wondering, but actually they were evading customs duties. Why wasn't this just a customs case? Well, cast your mind back to the beginning of this presentation. The Lacey Act means, right, you cannot illegally take any plant or plant product. If at any point the law is broken, it becomes a Lacey Act violation. So this is a great example of how the Lacey Act can function as an umbrella to other violations, right? It could be customs. It could be, basic compliance. It could be, CARB or TSCA violations, right? Anything at all can become a Lacey Act violation. Now, I didn't have time to put a slide together because this case was so incredibly recent, but there was a cabinet company that was out in the Northeast that just got sentenced last week. And they, again, it was a customs issue. They were trying to evade duties. And so they, I don't have all the details of the settlement just because I haven't had a chance to read through it yet. But essentially they have been given a compliance plan. They are going to be supervised for quite a while, significant fines. This is something that the US government has shown that they are willing to enforce and enforce often. One of the things we talk about in all of our courses is how you can see not only that the government is increasing the fines, increasing the penalties, making it the compliance plans more robust, but that they are putting more and more resources into trying to catch criminals. 2 cases in 1 year already, and we're only in June. I know for a fact that several folks from the FBI have been hired to start looking through declarations, through data mining, because they want to be able to start seeing trends and if they can catch some folks from the declaration side of things. So if you're thinking, well, none of these are my industry, right? And I haven't had any questions on this. You haven't had any questions on this yet. It hasn't been your industry yet. And so we always recommend that people take a look at some of these enforcement cases and recognize that the government takes this very seriously. So with that out of the way, let's talk about what this means practically for you. So your company obviously cares about this, right? Because I don't think any criminals have decided to join the AWFS webinar today, right? You guys want to do it right. And it's an ethical way to do business. I know no one here wants to trade in illegal products, right? I am sure of that. So what does that mean for me? It means you have to understand your supply chain. You have to create and then follow and improve your compliance program all the time. Lumber Liquidators, one of the reasons they got dinged, one of many, was that they had a compliance plan that they did not follow. And it was a lovely compliance plan by all accounts, right? Very thorough, great, but they set it up on a shelf and it collected dust. So you need to make sure that whatever processes you are building into trading, into your business, that it's something that you're constantly actually following and improving. So What does due care mean practically for you? Now, if you're an importer of record, I think you probably know at this point in the presentation that you definitely have to file that declaration, either currently if you have an HTS code that's already covered, or for phase 7 as of December 1. You also probably know that everyone in your supply chain, everyone has to exercise due care. No matter how far removed you are from that original harvest, it is still on you to provide due care. Honestly, it's helpful not only because it hopefully keeps you from trading in illegal wood, but if you have a very robust due care system, and Lord forbid, the US government knocks on your door and says, hey, we think that you have committed a Lacey Act violation. If you can show this robust due care system, if you can show documentation, if you can show a compliance plan, that's going to help your case. Maybe not, criminal felony, maybe it's a criminal misdemeanor, maybe it's civil, right? But it's important to know that that will help your case ultimately, the more due care you do. And the Department of Justice has made it very clear, like written down clear, that they consider the level of due diligence that a company has done in determining A, whether to pursue prosecution, and B, if so, how the penalties are rated. So the more work that you or your company are doing, the better off you will be, quite frankly. So there are 3 actions that can really be helpful when it comes to due care. The first is evaluate, right? You want to review your entire supply chain for risk, and you know your supply chain best. So where that risk lies is really going to be something that you will not me. Mitigate, right? So if you find risk, maybe it's a region, right? There's a region in a country that you trade in that has civil unrest. In that particular region, right? Maybe it's a county or a province, right? Well, what would be a way to mitigate that risk? Well, you might say, all right, well, I'm not going to source in that province, right? I'm going to make sure that my products are coming from, farther away, so that there's no chance that this could be caught up in these bribes or this civil unrest or this child labor issue or whatever it is. You want to find ways to mitigate. And then you have to justify, not only internally, but document it. How many times at work has someone asked you a question, and you're like, oh man, that was Jim. He used to work here. He had all that information, right? Let me dig through some files and see if I can find it. If the US government comes to you and says, hey, we have a question about a transaction we did 4 years ago, and you're like, well, that was Jim, and Jim doesn't work here anymore, that's not a good enough justification. You need to write down, you need to have something written that says, hey, I evaluated our product from this country, right? We found this risk, we mitigated in this way, and we feel comfortable trading because of that. And again, your 3 risk areas, broadly speaking, are going to be that source, species, supplier. So the source is going to be the country, the region, even down to the specific forest unit. If there are certain areas where there are corruption, right? Or it could be tied to someone with criminal background. There's the species. So certain plant species or products can be a higher risk, right? It might be a higher cost. The more expensive something is, the more likely that someone, if they're going to be criminal, right, are going to go for that high-end product versus something that doesn't have a high profit margin. And then, of course, there's your supplier / your supply chain, right? What work is your supplier or your supply chain doing? What are they giving you as evidence? What do those permits look like? How open are they being with you? Are you getting red flags? One of the biggest questions we get from folks is, how do I even start this, right? Like, this seems like a mountain and I'm all the way at the bottom. So how do I even start to make progress? So the first thing, and this sounds really silly, is to communicate your commitment to trade only in legally harvested wood, right? Just say it. And if I say it, I don't mean say it out loud in the morning to the mirror as, some sort of affirmation. I mean, say it in a written form, right? Write it down. Get it in your handbooks internally. Get it in any sort of process documents you have. Make sure that it is written in as many places as it is appropriate. You also want to get a written commitment from your suppliers, right? You want your supplier to say, I, to the best of my ability, am complying with all applicable laws. I want to be clear. This does not give you carte blanche to be like, oh, well, I don't have to worry about this because my supplier said it's legal, right? That written commitment from your supplier is only part of your due diligence. It is not a shield from liability. You need to identify the species and you need to ask questions about where things were harvested and your supplier's due care systems. So if you go to your supplier and you're like, hey, tell me about your due care. What are you doing to ensure you're compliant? And they look at you and they're like, don't worry about it. We're doing stuff. Don't worry about it. That would probably be a red flag, right? But if they're like, oh no, we have a whole, system to check permits, to do audits, let us show you, right? That's going to help when it gets back to that justification mitigation side of things for you to feel confident in trading. You need to consider tracking and traceability issues, right? How certain are you that the product that on paper started in this concession went to this supplier and came to you? How certain are you that that's the right thing that you're holding the paperwork for, right? How is the product and the paperwork being matched up as it moves through your supply chain? We always recommend that critical supply chain for suppliers provide greater documentation. What I mean by that is, let's say that 80% of your product comes from one supplier in one region, right? That's a significant portion of your business. You should probably have a higher standard for them. Maybe you're going out and auditing them sometimes in a way that you might not for some of the other suppliers. Whatever that looks like for you, just be aware that you should be asking for more from critical supply chain folks. There are a lot of scientific tools available. There have been great scientific strides made in identifying wood by sampling. So you should be aware of some of the technology that's out there. You should also think about what third parties can help you. There are a ton of them out there. If you need help on something and you're like, listen, I don't have the internal expertise, I want to outsource this. There are auditing firms, there are certification bodies, there are always lawyers, right? There's trade associations, there's universities, and there's even environmental groups. Again, you want to make sure to document your research and actions. If you have in your compliance plan that every 6 months you're going to do a search of all the environmental reports out there that deal with countries and products that you trade in, right? Document that. Because what you don't want to have is, okay, yeah, that's in my compliance plan, and the DOJ walks up and is like, hey, so there was this environmental group report about, products that you trade in the region that you buy from. And it says in your compliance plan that you check that sort of thing every 6 months. So did you check it? Did you see it? And if you did see it, what's your justification for continuing to trade? You need to be aware of things, and then you need to document your awareness. And I have to say, very selfishly, feel free to take our training for more tips and tricks. One of the most common questions I get is, how do you prove Lacey Act compliance, right? Because as a business, you want to say, okay, I'm compliant with the Lacey Act. I'm compliant with OSHA. I'm compliant with whatever, right? And then I can worry about actually running my business. The bad news is there is no single way to prove Lacey Act compliance. There is no document. There is no checklist that you can use to ensure legality. It is not a one-size-fits-all approach, and that is because the government has not provided the guidance on what might constitute Lacey Act compliance. I always share this. Due care is not a checklist. People want a checklist, right? You want to know that if I've checked these 6 documents and I've asked these 4 questions of these 3 people, that I'm good to go. That's unfortunately not how the Lacey Act works. It is evaluating your individual risk and then mitigating it. And sometimes, and this is really hard, sometimes it's making the hard call not to trade. You might have a supplier that you can depend on that has the exact product to the specifications you want. It's got a great price. You've got a long-standing relationship. But if they say, oh, we don't really worry about like laws, right? Like, we just don't worry about it. Like, let us worry about it. You don't need to worry your head about this. Like, we'll get you whatever paperwork you want, right? Even if all the other boxes are checked, sometimes the Lacey Act means that you can't trade with someone. And that's really hard from a business perspective and can quite frankly, be really hard from a sales, team perspective, from a accountant perspective, but empowering your compliance people, whoever they are, whoever is the person that is making that decision, to let them know that, yeah, sometimes the answer might be no. So I do just want to one more time emphasize, because I think a lot of folks further down the supply chain assume that they have some sort of shield, right? So let's talk about liability. So you have a concession owner, right? And this, again, is a very simplified supply chain. I know that many supply chains are far more complex than this, but let's say that the concession owner breaks a law, right? They're not paying their taxes because they don't want to pay, right? Or they're, cutting way more than their harvest permits allow, whatever it is. There's illegality with the concession. Under the Lacey Act, that illegality goes all the way down to the consumer. Now, I'll be very frank with you. I personally think it is incredibly unlikely that the DOJ is going to show up to a consumer's home, right, and seize something. That being said, under the lumber liquidators case, they paid extra penalties to ensure that the government did not go to consumers' homes and rip out flooring that they had concerns over being illegal. So the liability truly does go all the way to the consumer. But where the DOJ is most likely to focus is going to be the US side of things, right? Because they simply have more reach here. So starting with that US importer of record onto the purchasing company, processor, finisher, transportation, that brand name company, that is where the spotlight is going to be. So if you are in the US side of things, that is something you need to be aware of. With that, I will just end, because I know that this was a lot of information, and particularly for if any of you were not terribly familiar with the Lacey Act. I will recommend, we have a grant, IWP has a grant from the Animal Plant Health Inspection Service to offer our training for free. That's part of the reason I reached out to IWPA and said, hey, I'd love to do a webinar for you guys. So if you're interested in free Lacey Act on-demand training, so at your own pace, you can go to our website, or you can use this little QR code here, and you can register. And again, start, totally free. You don't have to put in a credit card, nothing like that. But feel free to go to our website. You can learn a little bit more. And then, of course, I'm happy to take any questions here if anyone has any. So maybe, Toby, I'll turn to you to see if any came in the chat.
No, don't seem to be any questions here. But I'll also just reiterate, if anybody has questions later, please feel free, reach out to Ashley with her email here. And I know she's happy to answer those or connect you with, any of those government agencies that you might want to talk to.
Yes, happy to do so. This can be a very complicated process, particularly if you're at the starting point of it. So feel free to shoot me an email, and I may not be able to answer, something specific to your product, but I can definitely get you in touch with people that can.
All right, and with that, I just want to say thank you again, Ashley. I really appreciate it, especially on, condensing things that are so complicated and making it easy to understand. So thank you.
My pleasure. Thank you guys for having me.
All right, thank you again. Bye-bye.
Bye.